the judgment is fully paid. Judgment sum is fully paid. Then M, the sum of 10 million naira as general damages. N, the cost of this action. The summary of the claimant's statement of facts, as can be gleaned from the claimant's last amended statement of facts, is that all the claimant was employed as a waiter by the defendant on the 12th December 2001, where he rose to the position of a waiter supervisor. After putting in 19 years of service, his appointment was terminated via a letter of termination dated 19th June 2020, stating that his services were no longer needed. On the termination of his employment, his terminal benefits were calculated as 353,905 naira 96 kobo in the termination letter instead of 769,085 naira 56 kobo, which is the proper amount due to him. His monthly salary in lieu of notice was calculated as 34,212 naira 52 kobo instead of 75,951 naira 52 kobo, leading to a shortfall of what he is entitled to as terminal benefits. Furthermore, during the pendency of his employment, there were some periods his salaries were short paid, just as some of his leave allowances were not paid. His ex gratia long service awards and money were never given to him. Despite writing letters of demand to the defendant to have all of these shortfalls corrected and paid his terminal benefit, the defendant has neglected or failed to attend to these demands. These have led to the nature of relief sought in this suit. In the defendant's amended statement of defense, dated 17th September 2024, but filed on the 23rd September 2024, the defendant, while admitting that the claimant was in her employment until the period his employment was terminated, stated, however, that the terminal benefit of the claimant was miscalculated to the tune of 353,905 naira 96 kobo. But when a review was done, it was discovered that the outstanding terminal benefit of the claimant was 190,968 naira 80 kobo, which has since been paid to him. On salary in lieu of notice, the defendant stated that there was earlier miscalculation, which used the basic salary of 35,000 as the basis of calculating the salary in lieu of notice. However, this miscalculation was later corrected, and the gross salary of 75,915 naira 52 kobo was used in the recomputation of the claimant's benefits, to which a sum of 75,961 naira was paid to him as salary in lieu of notice. On the golden handshake / good leave exit package, the defendant stated that it was implemented in 2018, but following a review by the trustees of the defendant in 2019, the decision was reversed as a general committee meeting of 29 January 2019. As for the leave allowance in 2019, the defendant contends that the claimant was paid his leave allowance in December 2019. On the leave allowance for 2020, the defendant stated that the claimant was paid the sum of 74,315 naira 42 kobo as prorated leave allowance for the year 2020 in the recomputed terminal benefits, a sum which is above 69,773 naira 92 kobo claimed by the claimant. Flowing from the above, the defendant posited that this suit is misconceived, unmeritorious, and frivolous. Therefore, same should be dismissed with substantial cost. Trial in this matter commenced before this court on the 27th day of February 2025, to which the claimant himself testified as CW1. He adopted his witness statement on oath of 22nd April 2024 and tendered documents that were admitted and marked as Exhibit 1 to Exhibit 15. Subsequently, he was cross-examined by the defendant's counsel. There was no re-examination. Thereafter, the claimant closed his case. On the part of the defendant, she opened her defense on the 21st day of May 2025 by calling one Elizabeth Esowe, who adopted her witness statement on oath of 23rd September 2024 and gave oral testimony, tendered documents that were admitted in evidence as Exhibits D1 to D9. She was cross-examined by the counsel to the claimant, and there was no re-examination. Thereafter, the defendant closed her defense. The case was then adjourned to enable parties file, exchange, and adopt their final written addresses. Now, in the defendant's final written address, which was dated 5th September 2025, but filed on the 10th September of the same year, learned counsel to defendant formulated a sole issue for determination, and that is whether the claimant is entitled to the relief set out before the court. The defendant's counsel posited that the claimant's case is predicated on two major complaints: the alleged wrong computation of his terminal benefits and the non-payment of exit benefits and ex gratia payment in recognition of service. On alleged wrong computation of claimant's benefits, defense counsel, while relying on the evidence and testimony of DW1, submitted that the defendant has paid the sum of 190,968 naira 80 kobo to the claimant, and this sum is the final sum the claimant is entitled to as terminal benefit. The receipt of the check containing this sum is evidenced in Exhibit D8, which is the letter of 9th August 2024 from the defendant's solicitor to the claimant's solicitor. On the non-payment of the exit benefits and ex gratia payments for long service, learned counsel to the defendant submitted that the defendant is not liable to make such payments as claimed by the claimant, as these payments do not form the contract of employment between the defendant and the claimant. That in any dispute as to the rights and obligations of parties arising from a contract of employment, the contract of employment must be pleaded and proved. He referred the court to the case of Morohun Fola, the Kwara State College of Technology, reported in 1990, for Nigeria Weekly Law Reports, page 506. Sorry. That in the case hearing, the claimant pleaded as evidence his letter of employment and Ikoyi Club 1938 Junior Staff Handbook. A careful reading of both documents will reveal that there is no provision for exit benefits and ex gratia payment in recognition of service. That no evidence was laid by the claimant explaining what he meant by the two terms or where to find them in the body of the contract of employment. In this vein, the claimant has failed to show his legal entitlement to this particular claim. Defense counsel proceeded further that from paragraphs 14, 15, and 16 of the claimant's witness on oath, the claimant gave the impression that his entitlement to this claim is derivable from a collective agreement, which was solidified by the minutes of a meeting of 27th November 2018. However, there is no evidence of the collective agreement before the court, nor is there any mention of same in Exhibit C6, which is the minutes of the meeting of 27th November 2018. Therefore, the claimant failed to lay any foundation for his claim for the good liver exit package. And in this vein, his claim under this head must fail. Learned counsel to the defendant submitted that ex gratia payments, especially those not contained in any contract of employment, are not enforceable as a right. He relied on the case of Mr. Haruna Ishola Salahu versus Sterling Bank PLC, unreported, suit number NICM/ABJ/36/2022. On collective bargaining agreements, defense counsel submitted that before it can be enforced, a lot of factors need to be considered, which include A, whether its terms have been incorporated into individual contracts of employment, either expressly or by implication. B, the existence of a valid dispute resolution clauses within the CBA. C, whether the CBA is current, expired, or has been renewed or renegotiated, as seen in the case of NUHPSW versus Outsourcing Services Limited, is an appeal, Lagos Court of Appeal of July 17, 2023, where the Court of Appeal upheld the decision of the NICM that the CBA was no longer enforceable because it had expired and no renewal allegation was made. The defense counsel submitted further that a collective bargaining agreement is not enforceable except it is incorporated or adopted into individual contractual terms. He relied on the case of Ono versus Unity Bank PLC, reported in 2013, 9 Nigeria Weekly Law Report, Part 1358, page 1. On long service award, defense counsel submitted that the mere mention of a benefit in a handbook without proof that the handbook forms part of the binding terms of the employment or that the benefit has been consistently implemented does not confer a legal entitlement. He referred the court to the case of Abdullahi Ibrahim and 3 others versus Presal Nigeria Limited, suit number NICM/PH/134/2018, judgment delivered on the 23rd day of January 2023. It is the submission of learned counsel to the defendant that the defendant has fulfilled its obligation to the claimant, and in the light of this, the court should hold the same. In the claimant's final written address dated 3rd October 2025, but filed on the 8th of October 2025, claimant's counsel formulated 4 issues for determination. 1, whether the claimant and the defendant are bound by the terms and conditions of service as contained in the Ikoyi Club Junior Staff Handbook, that is Exhibit 3, C3, or D3. If the answer is not negative, whether the claimant is entitled to a long service award in accordance with Article 17 of the Ikoyi Club Junior Staff Handbook. 2, whether Clause 6 of the minutes of the general meeting dated 22nd November 2018, that is Exhibit C5 or D6, applies to the claimant as a junior staff member of the defendant. If the answer is not negative, whether the claimant is entitled to a 3-month gross salary handshake / good liver exit package in accordance with Exhibit C5 or D6. 3, whether the claimant is entitled to recover the sums that the defendant wrongly deducted from his salaries and prorated leave allowance. And 4, whether the defendant is entitled to the claim for general damages or costs of action in the circumstances of this case. On issue number 1, Claimant's counsel submitted that the threat law is that parties are bound by the express terms of their contract of employment when those terms are clear and unambiguous. He relied on the case of C&N Investments Limited versus Sterling Bank PLC and another, reported in 2024, LPELR 62863, Supreme Court. He also referred the court to the Registered Trustees Esowe Club 1938 versus Iku Juni, reported in 2019, LPELR 47373, Court of Appeal, where the Court of Appeal held inter alia that since the handbook was admittedly the foundation of the contract of employment between the appellant and the respondent, and it contained the terms and conditions of employment, it was applicable to the employment, and both the appellant and the respondent were bound by it. That in the case herein, clause 5 of the employment letter of the claimant expressly stated that, quote, other conditions of the claimant's employment are as contained in the Esowe Club 1938 standard regulation and conditions of service for junior employees, unquote. In this vein, Exhibit C3, which is the handbook, is incorporated into the employment of the claimant. Claimant's counsel therefore urged the court to reject defense counsel on this head. The claimant's counsel submitted further that Article 17 of Exhibit 3, C3, that is the defendant's handbook, provides for long service awards. Therefore, in line with Article 17, the claimant is entitled to a small deep freezer of not less than 140 liters and a plaque. That the defendant's neglect to fulfill this obligation clearly breached the contract and makes the defendant liable in damages. On issue number 2, claimant's counsel submitted that where more than one document set out the terms of employment, those documents must be interpreted and determined together. He referred the court to the case of Oladipo versus Chevron Nigeria Limited, reported in 2005, and also Baba versus Nigeria Civil Aviation Training and another, reported in 1991. Both citations fully supplied here. The learned counsel posited further that the law is well settled that where a person has intentionally caused or permitted another individual to believe a fact to be true and acted on that belief, neither he nor his representative in interest shall subsequently be allowed in any proceedings between the parties and their representatives in interest to deny the truth of such facts. He referred the court to the case of CBN versus Dine, reported in 2021, 15 Nigeria Weekly Law Report, part 1798, page 91, and also to the case of Skybank PLC versus Adegu, reported in 2024, LPELR 62219, Supreme Court. that in the case hearing, during the pendency of the employment of the claimant, the defendant, through Exhibit C5, that is minutes of the 27th November 2018, declared, approved, and ratified the payment of 3 months' salary as golden handshake or good liver exit package for both junior and senior staff who have served at least 10 years at the time of their departure from the defendant's organization. This policy was implemented from 1st January 2018 as admitted by the defendants in paragraph 11 of their witness statement on oath. The claimant, on his part, worked for 18 years and 6 months before his employment was terminated, yet the defendant has refused or neglected to pay him his golden handshake entitlement. Claimant's counsel submitted that the above being the case hearing, the defendant cannot renege on the promise to pay the claimant the golden handshake package after the claimant has served the defendant for 18 years and 6 months. On the position of the defense that the golden handshake provision was reversed or discontinued, claimant's counsel submitted that it is the defendant that has the burden of proving this reversal or discontinuation, that a perusal of Exhibit D7 will reveal that the document was not duly executed. The document was not signed, therefore worthless and lacking efficacy in law. He relied on the case of Aliyu versus Nemadi and others, reported in 2023. And the case of Omega Bank Nigeria Limited versus OBC Limited, reported in 2005, both citations fully supplied. On the defense counsel's submission that since the good liver exit package is not contained in the employment letter of the defendant's handbook, therefore the claimant has no legal basis or evidence of entitlement to same, claimant's counsel submitted that the approval of the good liver package is based on the existence of the employment letter and the defendant's handbook, which is the foundation of the contractual relationship between the claimant and the defendant. It is the submission of the claimant's counsel that the refusal of the defendant to pay claimant's 3 months gross salary as good liver exit package demonstrates bad faith and a breach of a binding promise voluntarily made by the defendant. He therefore urged the court to hold that defendant is liable for general damages. On issue number 3, claimant's counsel submitted that the settled law is that he who asserts must prove, and the burden of proof in every suit rests with the party who fails if no evidence is given on either side. Also, by virtue of Section 167 sub D of the Evidence Amendment Act of 2023, where a party withholds which is available but not produced in court, it is presumed that the evidence, if produced, would have been unfavorable to the party. Refer the court to the case of Bakari versus Ogundikwe and others, reported in 2020, citation fully supplied. That from the evidence before the court, as well as evidence elicited from DW1 during cross-examination, the defendant used the standard computation method to assess the claimant's monthly tax and pay as you earn deductions were made from the claimant's salary on a monthly basis. There is therefore no evidence from the defendant to prove the amount of income tax it allegedly deducted from the claimant's salary in 2018 and 2019, the basis of such deductions, or the amount it ought to have deducted. No audit report from Lagos State Inland Revenue Services tendered by the defendant to substantiate any claim of under deductions or under deductions. There's no evidence substantiating bar shortages as alleged by the defendant to warrant the deductions made in the claimant's terminal benefits. Learned Counsel submitted that assuming without conceding that the defendant has proved the allegation of payee under deduction, the provision of section 81 sub 1 and 82 of the Personal Income Amendment Tax of 2011 provides that if the employer fails to make tax deductions as at when due, the penalty for such is borne by the employer, not the claimant. That in the case hearing, the defendant unlawfully deducted several amounts from the claimant's salaries and prorated leave allowance under the guise of 2018 and 2019 payee when based on the Personal Income Amendment income tax cited above. It was the defendant who was supposed to bear such responsibility after failing to make such deductions as at when due. It is the submission of claimant's counsel that the defendant has failed to justify the unlawful deductions made from the claimant's salaries and prorated leave allowance. Therefore, the claimant is entitled to a refund. On issue number 4, claimant's counsel submitted that damages have been defined as pecuniary compensation awarded to a successful party and in an action for a wrong, whether arising from a tort or breach of contract. It is the submission of claimant's counsel that the defendant, having failed to pay the claimant his terminal benefit, is in breach of contract of employment between the claimant and the defendant, and as such, the claimant is entitled to damages. Conclusively, claimant's counsel urged the court to grant the relief sought by the claimant. On receipt of the claimant's final written address, the defendant filed a reply on point of law dated and filed on the 13th day of October 2025. Then, all said and done, the court, having gone through the case of the claimant, defense of the defendant, and evidence laid by the claimant and the defendant, this court has distilled a sole issue for determination, and that is to say, whether the claimant has proved his case to be entitled to the relief sought. The settled law is that burden of proof rests on who assets. A civil case is decided on the preponderance of evidence. See the case of Ayetoro TRAD, that is Community or Traditional Company Limited, versus NACB, reported in 2003. Citation fully supplied. The person who bears the primary burden of proving by preponderance of evidence is the person whose case would fail if no evidence was adduced. It is of no consequence if the defendant fails to give evidence. See the case of Alhaji Tajuddin Ibrahim Olagunju versus Alhaja Habibat Yahaya, reported in 2004. 11 Nigeria Weekly Law Report, part 883, page 24, where the Court of Appeal held, quote, in a civil suit, the person who assets has the primary burden of proving his assertion. The failure of the defendant to prove or his refusal to testify cannot alleviate the primary burden on the plaintiff, unquote. For all it is worth, the defendant may just decide to fold his hands and give no evidence, because after all, the case of the claimant can only the case of the claimant can only succeed on his own strength and not on the weakness or lack of strength of the case of the defendant. See the case of Isamatu A. Ashiru versus Adetoto Olukoya, reported in 2006. 11 Nigeria Weekly Law Report, part 990, page 1. However, for the purpose of evidential proof, if the defendant enters a defense and makes averments, it behoves the defendant to lead evidence in support of such averments to satisfy the court that such averments are not baseless, but supported by facts and evidence. In this vein, evidential proof of facts becomes a pendulum that swings both the way of the claimant and the defendant, each leading evidence in support of their averments whenever the pendulum of evidential proof swings their way. That said, the court will look at the case of the claimant to see if by preponderance of evidence the claimant has proved his case to be entitled to the relief sought, whilst also looking at the defense of the defendant to ascertain how far the defense has been able to lead evidence in support of the averments made in their own defense. The case of the claimant hearing arose from an employment relationship between the claimant and the defendant that spanned from December 2001, when the defendant employed the claimant, to June 2020, when the defendant terminated the employment of the claimant. In this case, it was the defendant who hired in December 2001 that fired in June 2020. There is no dispute as to whether the claimant was employed in 2001, nor is there any dispute as to whether employment of the claimant was terminated by the defendant in 2020. What is in dispute, however, is the claimant's unpaid monetary entitlements prior to the termination of his employment in June 2021 and his terminal benefits, both in cash and kind, post termination of employment. From Exhibit C2, which is the letter of termination titled Services No Longer Required, dated June 19, 2020, the defendant itemized the terminal benefits of the claimant as follows. 1. Monthly basic salary in lieu, 34,212 naira 52 kobo. 2. 2019 leave allowance, 148,630 naira 86 kobo. 3. Ex gratia in recognition of services, 171,062 naira 86 kobo. Total terminal benefits payable, 353,905 naira 96 kobo. In another letter, that is Exhibit D8, from the Rose Chamber of the Counsel to the defendant, it mentioned that the terminal benefit of the claimant was recomputed and that all that was left of the terminal benefit was 190,968 naira 80 kobo. Even though the letter mentioned that it was discovered that the claimant had been paid the bulk of his entitlement, and all that remained was 190,968 naira 80 kobo. It seems to me that the recomputation was not really a testament that the bulk of the claimant's entitlement had been paid, but rather it was a case of a downward review of the claimant's terminal benefits from the earlier 353,905 naira 96 kobo in the termination letter to 190,968 naira 80 kobo, as stated in Exhibit D8. In the defendant's statement of defense, She gave a tabular representation of how she arrived at the sum of 190,968 naira 80 kobo, now alleged as the terminal benefit of the claimant. But it seems the claimant would have none of this. And so in his statement of facts, he stated that what the defendant owes him is in cash to the tune of 769,085 naira 59 kobo, and in kind to the extent of a deep freezer, not less than 140 liters, and a plaque. The claimant's entitlement on the above terminal benefits is rooted in his employment letter, the defendant's handbook, and the minutes of the meeting of 27th November 2018. The position of the defendant is that the minutes of meeting of 27th November 2018 is moribund and has been replaced by another minute of a meeting of 29th January 2019, which cancelled out the provisions of clause 6 of the minutes of meeting of 29 November 2018, which makes provision for 3 months gross salary for staff and have worked for the defendant for 10 years and above, with effective date being 1st January 2018. Between both minutes of meetings, the claimant wants the court to apply that 27th November 2018, while the defendant wants the court to apply that of 29 January 2019. Be it as it may, and being that the court was not there when either of them was made, the court can only, at this stage, take a keen look at both documents and determine which is applicable based strictly on facts and law. From the facts, the existence of the minutes of the meeting of 27th November 2018 is not in doubt. It was admitted by both parties. However, as to the minutes of the meeting of 29 January 2019, the claimant disputes its existence. It is only the defendant who raised its existence and elevates it to the level of cancelling out the 27th November 2018 particular as it relates to 3 months gross salary. Exhibit C5, that is the minutes of meeting of 27th September 2018, is dated, legible, and signed by one Mr. Babatunde Akinloye, designated as chairman, and one Mr. Olukimle Oyewole, Esquire, designated as honorary secretary. On the other hand, Exhibit D7, that is minutes of the meeting of 29th January 2019, is dated. It's partly blurred and unsigned. I practically strained my eyes so much to read the parts highlighted, but it is obvious the object of the highlighted part is not to highlight it, but to blur it. As such, I could hardly piece everything together. Secondly, Exhibit D7 was not signed, raising the presumption that it was never executed. By these factors, Exhibit C5 is superior in law and fact to Exhibit D7. Furthermore, being unsigned, Exhibit D7 may not worth more than the paper it was written on. Be that as it may, the settled law is that an unsigned document is a worthless document. See the case of Maku versus Alao Akala, reported in 2010. See also Uzokwelu versus PDP and others, reported in 2018. Citation supplied. Being worthless, it is not a document the courts cannot act on or enforce. Such a document is a dead piece of paper with no legal status, value, or efficacy. If such a worthless document has been accidentally admitted the court will do well to expunge SEN from its records, having discovered that it was a worthless document ab initio. Consequently, the court finds that Exhibit D7 is a worthless document and ought not to have been admitted at all. Therefore, Exhibit D7 is hereby expunged from the record of the court, and I so hold. Having found that Exhibit D7 is a worthless piece of paper with no evidential value, and having expunged SEN from the records, the only credible valid evidence for the court on the 3-month gross salary is Exhibit C5. In the absence of any superior documents, the court shall therefore apply Exhibit C5 in this case. In the defendant's final written address, the defense counsel argued that the mere mention of a benefit in a handbook without proof that the handbook forms part of the binding terms of the employment or that the benefit has been consistently implemented does not confer a legal entitlement. He went on to posit that there is no nexus between Exhibit C1, that is the claimant's employment letter, and Exhibit C3, that is the defendant's junior staff handbook. This opinion is for the purpose of arguing that the claimant was not vested with the legal rights to derive benefit from Clause 17 of Exhibit C3, which provides for a small deep freezer, not less than 140 liters, and a plaque for staff who worked for 15 years in service. The basis of the defendant's argument is that there is no connection of the employment letter of the claimant to the handbook to entitle him to benefits derivable from the handbook. This raises the question if an employment letter and the handbook can stand alone and enforceable absent from each other. In the case of Nimasa versus Esowe, reported in 2014, citation supplied, the court held that, quote, a claimant who seeks a declaration that his employment has been wrongfully terminated must prove the following material facts, namely, A, that is an employee of the defendant, B, terms and conditions of his employment, and C, the way and manner and by whom he can be removed. It is not in principle for the employer who is a defendant to an action brought by the employee to prove any of this. In the case herein, the claimant's right to a deep freezer and a plaque is tied to his employment letter, by which a contractual relationship was established between him and the defendant, and Clause 17 of the junior staff handbook of the claimant. As to whether there is a nexus between the employment letter and the handbook, paragraph 5 of the employment letter reads, quote, other conditions of your employment are as contained in the Esowe Club 1938 standard regulations and conditions of service for junior staff, junior employees. From the above, it is concrete that the terms and conditions of the employment of the claimant are not limited to the employment, but extended to other conditions stated in a document christened as Esowe Club 1938 standard regulations and conditions of service for junior employee. The claimant's argument is that this established a link between the employment letter and the provisions of the defendant's Esowe Club 1938 junior staff handbook. I must pause here to say that what is in evidence before me is christened Esowe Club 1938 junior staff handbook and not Esowe Club 1938 standard regulations and conditions of service for junior employee. However, being that what the claimant and defendant tendered before me is titled Esowe Club 1938 Junior Staff Handbook, This court will apply the rule of thumb and hold that from all indication, it is the Esowe Club 1938 Junior Staff Handbook that was applicable as at the time of the cessation of the employment of the claimant in 2020, even though it is probable that the Esowe Club 1938 standard regulations and conditions of service for junior employee existed as at the time the employment of the claimant in 2001. This rule of thumb has its legal footage in the Supreme Court's decision in Godfrey Esowe versus NEPA, reported in 2002, LPELR 1555 Supreme Court, where the Supreme Court made it clear that in employment matters, rights and benefits are determined by the policy in force at the time of cessation of the relationship. From all that have been said above, this court finds and holds that the claimant's terms and conditions of employment extends to the provision of the Esowe Club 1938 Junior Staff Handbook. Therefore, the claimant's claim on his benefit derivable from clause 17 of the Esowe Club 1938 Junior Staff Handbook is well-founded, and I so hold. Among the particulars of the monetary claim of the claimant is one titled ex gratia in recognition of long service, and is to the tune of 171,062 naira 86 kobo. The defendant strongly contested this in her final written address, arguing that there is no provision for ex gratia in the claimant's employment letter or the defendant's handbook. I have carefully gone through the claimant's employment letter and the defendant's handbook. There is nowhere provision is made for any terminal benefit called ex gratia. That notwithstanding, it seems to me that it was the defendant who actually introduced the term ex gratia in recognition of service in Exhibit C2, which is employment termination letter from the defendant to the claimant. I want to believe that the claimant ran with this without cross-checking if it is in his employment letter or the handbook. Be that as it may, it is not the duty of the court to rewrite agreements for parties. In this vein, being that the ex gratia benefit is not an entitlement, the claimant has laid any proof on, then there is no basis for him to derive any entitlement from same. In this vein, in the relief of the claimant on this head is bound to fail, and as I read. Still on ex gratia. Generally, an ex gratia is a payment given as a favor or as a sense of moral obligation, rather than because of any legal requirement. This is the more reasons the courts are always unwilling to enforce any claim which ex facie is grounded in ex gratia. However, when the claim has to do with terminal benefits, which is rather harmful, terminal benefits, which is intended to serve as gratuity or severance allowance, the court finds it rather harmful and offensive for an employer to see such end terminal benefits as a favor he's doing to the employee. As such, he could elect to do such favor or not to do it. The truth is that terminal benefits are not favors that lies at the discretion of the employer to do or not to do. Rather, they are mandatory on every employer to exercise, the employee having met the conditions precedent to such terminal benefits. In the case herein, A condition was set for such benefits: work for 10 years on one hand, and on the other hand, work for 15 years. The claimant worked for 18 years, and having worked with the defendant for 18 years, he has furnished consideration for him to be entitled to his claim. Not only that, he has met the legal requirements set out in the defendant's handbook to be entitled to small deep freezer of not less than 140 liters and a plaque, just as he is entitled to 3 months gross salary as provided in the minutes of meeting of 29th September 2018. The need to clarify the position of the court on ex gratia is done to disabuse the mind of the defendant, just in case she's thinking that the provisions of clause 17 of the Esowe Club 1938 Junior Staff Handbook on long service award is ex gratia or at the discretion of the defendant. It is not, and it can never be at the discretion of the defendant, because for all intents and purposes, it does not qualify as ex gratia award. Its intent is not to award discretionarily, but to award based on a condition precedent. Therefore, if the condition has been met, it is a subterfuge, an aberration, and breach of the claimant's right to turn around and say it is ex gratia. Even in the world of sports, say African Cup of Nations, there is no way a nation, after surviving the group stage to the knockout stage, from the knockout stage to quarterfinal, from quarterfinal to semifinal, and from semifinal to final, and after winning its opponents at the final, the CAF will turn around and say the Golden Cup is an award. That award is ex gratia. So it has the discretion to award it or not to award it. That alone will be chaotic. Just imagine that this had happened in the just concluded Nations Cup. Just as every game has rules, so also every employment has rules. Therefore, if an employee has played according to the rules and he has run the race till the final, no rules should be used to deny him of his terminal benefits, especially when such benefits are tied and calculated on how long he endured and worked in the employment of the employer. If an employee endured and worked till the end, he should also enjoy and live his remaining life in peace. From all that have been said above, and from the form and intent of clause 17 of the defendant's handbook, as well as Article 6 of the minutes of meeting of 27th September 2018, this court finds and holds that the claimant, having fulfilled his side of the bargaining by working for more than 18 years with the defendant, before the defendant unceremoniously terminated his employment, the defendant is under legal obligation to give effect to clause 17 of the defendant's handbook, as well as Article 6 of the minutes of meetings of 27th September 2018, as regards the claimant's terminal benefits, be it cash or kind. The defendant in Exhibit C2 of 19th June 2019, which is employment termination letter, served the claimant, calculated the total terminal benefit of the claimant to be 353,905 naira 96 kobo. However, by a twist, while this matter is sub judice, another letter, that is Exhibit D8, was sent to the claimant, informing him that his terminal benefit has been slashed to 190,968 naira 80 kobo. after a recomputation was carried out. In the defendant's amended statement of defense before this court, while giving particulars of this slash, sounded magnanimous and not frugal. She stated her magnanimity in paying the claimant a sum above 75,951 naira 52 kobo, claimed by the claimant as salary in lieu of notice. A 2019 leave allowance, a 2020 prorated leave allowance above the 69,773 naira 92 kobo claimed by the claimant. Salary arrears above the 75,811 naira 87 kobo claimed by the claimant. However, embedded in this is a large chunk of money deducted as tax or money for under deduction of tax during the pendency of the employment of the claimant, and deductions christened bar shortages. To the defendants, the tax deductions are based on the fact that the defendants realized it under deducted the claimant's income tax of pay as you earn between 2018 and 2019. The deductions were therefore made to cover up for such under deductions. But the claimant would have none of these deductions. In the claimant's final written address, claimant's counsel argued that there is no evidence from the defendant to prove the amount of income tax it allegedly deducted from the claimant's salary in 2018 and 2019, the basis for such deductions, or the amount it ought to have deducted. No audit report from Lagos State Inland Revenue Services tendered by the defendant to substantiate any claim of under deduction. No evidence substantiating bar shortages as alleged by the defendant to warrant the deductions made in the claimant's terminal benefit. The claimant's under deductions in the personal service income tax of the claimant, the penalty for such ought to be borne by the defendant and not the claimant. He relied on sections 81(1) and 82 of the Personal Income Amendment Tax of 2011. The allegations of the defendant on deductions made on the terminal benefit of the claimant stands on shaky legs for two reasons. The first reason is that our organic laws frown at deductions from pension, gratuity, and terminal benefits accruing to an individual after working for donkey years. This is understandable and at the same time desirable, so that whatever is being paid as a final fruit of years of labor should be enjoyed without any encumbrances of tax. From sections 173 and 210 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, to the third schedule of section 19(1) of Personal Income Tax Act, pensions, gratuities, and retirement benefits are exempted from tax. Expressly, third schedule of section 19(1) of the Personal Income Tax provides, and I quote, pensions, gratuities, and other retirement benefits granted by the government or under any law, written law, are exempt from tax, unquote. Therefore, in the case herein, if the money being taxed from part of the terminal benefit of the claimant, such taxing has been outlawed by our organic laws. Secondly, and as earlier highlighted, evidential proof of facts is a pendulum that swings either way. On this matter on deductions, Evidential proof of such fact swings the way of the defendant, and it becomes his duty to lead evidence in proof of same. Therefore, if they were under deductions, she should prove it. If there were bar shortages at the instance of the claimant, she should prove it also. The defendant, just as the claimant, owes the court the duty of leading evidence in support of his pleadings. See IBWA Limited versus Emmanuel Nigeria Limited, reported in 2001, FWLR Part 44, at page 444, paragraphs A to B, where the Supreme Court held, and I quote, "It is the law that pleadings cannot constitute and does not tantamount to evidence, and a defendant who does not give evidence in support of his pleadings or in challenge of his evidence of the plaintiff is deemed to have accepted the facts in dispute as adduced in the evidence by the plaintiff, notwithstanding the general traverse in his pleadings. As it stands, in the case hearing, there is no proof before me evidencing the reality of under deductions in the income tax of the claimant, as alleged by the defendant, just as there is no proof of bar shortages at the instance of the claimant. In the absence of proof, the best part for the court to tour is as stated in the case of University of Ilorin versus Rashid Adeshino, Rashidat Adeshino, reported in 2010, citation supplied, where the court held, and I quote, "No matter how impressive a party's pleading may be, it is of no consequence if not supported by concrete and credible evidence in proof thereof. Where no evidence is adduced in support of averment in pleadings, such averments are deemed abandoned," unquote. So in the light of the above, and given the absence of evidence on the deduction and bar shortages, this court finds and holds that the pleadings of the defendant on this head shall be deemed abandoned, arising from want of evidence. Consequently, there is no evidential basis for the defendant to make deductions from any money that forms part of the claimant's benefit, or legal basis for the defendant to tax any part of the money of the terminal benefits accruing to the claimant. In Relief 11, the claimant asked for a prejudgment interest of 21% of the judgment sum per annum. This court wishes to state that the prejudgment interest is not granted for the asking. A claimant who seeks relief in prejudgment interest should be able to plead as well as prove his entitlement to the prejudgment interest. See the case of Diamond Bank Limited versus Partnership Investment Company Limited and another. Citation supplied is a Supreme Court case. More so, to be successful in a claim of prejudgment interest, a party must establish by means of credible evidence that there exists an agreement, mercantile usage, or statute enabling / entitling him to claim prejudgment interest. See Pedgas Resources Limited versus Mbanefo, quoted in 2007. Citation fully supplied. In the case hearing, the claimant has not shown, by way of the means referred to above, on how he is entitled to prejudgment interest of 21% per annum. In this vein, his claim on prejudgment interest is bound to fail, and I so hold. Claimant's relief number 12 on 21% post-judgment interest is also bound to fail, because given the facts and circumstances of this case, the court is not moved to grant any sum or percentage in post-judgment interest. In Relief 13 of the claimant's relief, the claimant seeks 10 million naira damages, general damages. I have looked at the nature of this case, And from the circumstances of this case, this court is of the view that awarding a 10 million naira damages in addition to what the claimant claims may just be awarding a bonus to the claimant. I am well guided by the decision of the court in Makinde versus Omagoni, quoted in 2011, citation supplied, where the court held as follows. Sorry. And I quote, once a party has been fully compensated for the loss or harm suffered by him, it should not be open to the court to proceed to award him any other kind of additional damages that may look like a bonus, unquote. In this vein, the court is not minded to grant any sum or sums of 10 million naira as damages, and I so hold. So in all, the claimant's case succeeds as follows. Relief number 1 succeeds. Relief number 2 succeeds. Relief 3 succeeds. Relief 4 succeeds. Relief 5, 6, 7. 5 and 6 succeed. Relief 7 succeeds only to the extent that it shall be less 171,062 naira 86 kobo, which the claimant allotted as ex gratia in recognition of services, but could not substantiate with evidence. So it shall be less this. Okay. Relief number 8 succeeds. Relief 9 succeeds only to the extent that it shall be less 171,062 naira 86 kobo, which the claimant allotted as ex gratia in recognition of service, but could not substantiate with evidence. Relief 10 succeeds. Relief 11 fails, for given the circumstances of this case, it is not one that qualifies for pre-judgment interest. Relief 12 fails, for given the circumstances of this case, this court is not moved to grant any post-judgment interest. Relief number 13 fails. Relief 14 succeeds to the extent that cost follows event, and also based on the settled law that a court can exercise its discretion in awarding costs to a successful party who comported himself well before the court. And at this, the court assessed here. The cost assessed here shall be 300,000 naira only. And that is the judgment of the court, which is entered accordingly.
As the court pleases, we're most grateful to the considered judgment of the court.
Okay. Did you say anything?
My Lord, we are most grateful, my Lord, for the well-delivered judgment. I will pray for more elevation, my Lord, as the court pleases.
Because the reliefs are so many, the judgment was very long, but it doesnn't matter.
We're most obliged.
Thank you. Okay. So the next one. That's so good. Okay. Appearances, please.
With profound respect to my Lord,
Yes.
my name is Tanimola Oyekon.
Ade.
Tanimola Oyekon. Tanimola Oyekon.
Yes.
Appearance is for the claimants.
Okay.
Thank you, my Lord.
Yeah. Very well. Who is for the defendants? How about for? In the courtroom here. Counsel, you are in the courtroom. Oh, you are muted. Please, can you please call Shem to come? I think he's talking, but we are not hearing it. You are muted. Oh, unmute.
Mute.
Okay.
Very well, my Lord.
Yes, yes.
Yes, my Lord.
Okay.
For the defendant, but I did not quite hear the name of the case, in case it is not because of the counsel that announced for the claimant is strange to the case.
CN/LS/17/2022.
Oh, very well, very well. It is the right case, my Lord. Yes, my Lord.
So your
O.C. Abafo.
Okay.
My humble appearance, my noble Lord, is for the defendant, the first defendant.
Okay. Defendant. Yes. Who is for the? Okay, there's no legal representation for the second defendant.
There's none, my Lord.
Okay. No legal. Very well. This is a ruling.
Yes, my Lord.
Yes. So this suit was instituted by the claimant via the general form of complaint dated and filed 18th January 2022, asking for the following reliefs. A declaration that by virtue of the second defendant's letters dated 14th March 2013 and 20th November 2014, and the first defendant's memo dated 22nd July 2021, and other letters dated, the claimant's gratuity and accumulated pension arrears ought to have been calculated and paid by the first defendant on the basis of the prevalent 2011 salary structure of grade level 7, step 6 of the first defendant. B, an order for payment of the sum of 1,024,876 naira 84 kobo as outstanding short payment of the claimant's gratuity. C, an order for the payment of the sum of 3,207,471 naira 2 kobo as outstanding short payment of the claimant's pension arrears from 13th September 2011 to 30th April 2021. And D, order for the payment of the sum of 40,731 naira 54 kobo as monthly pension to the claimant, effective from 1st May 2021. And E, interest on the above sum of 1,024,876 naira 84 kobo and 3,207,471 naira 2 kobo at the rate of 25% per annum from November 2000. I have to go back to the question because this date, there is no year that is 201. Maybe 2011, but I will correct it. Till date of judgment, and thereafter at the rate of 10% till the judgment sums are fully liquidated by the first defendant. Then by a notice of preliminary objection by the first defendant brought pursuant to section 81(1) of the Nigerian Railway Corporation Act, section 6 sub 6b of the Constitution of the Federal Republic of Nigeria, 1999 as amended, and under the inherent jurisdiction of this court, the first defendant praised the court for an order striking out the claimant's suit for want of jurisdiction of this honorable court to entertain the suit. The grounds for the objections are: A, claimant's alleged cause of action accrued, according to the claimant's pleadings, between September 2013 and 24th November 2013, when he claims to have been short-paid his pension arrears because the calculation principle applied to compute it was wrong. B, upon becoming aware of the alleged wrongful calculation and short payment, the claimant elected to pursue non-judicial options that failed. C, the claimant instituted this action on the 18th day of January 2022, more than 8 years after the alleged cause of action had occurred. D, by the provisions of section 83 sub 1 of the Nigerian Railway Corporation, no action can lie or be instituted in any court against the corporation or any of his servants for any alleged cause of action after 12 months of the occurrence of such a cause of action. E, by section 6(b) of the Constitution of the Federal Republic of Nigeria, the jurisdiction of this honorable court can only be activated where there is a justiciable dispute between parties. F, claimant's right to seek judicial redress for alleged short payment or any other infraction all arose from the same alleged action that happened in 2013 and has been extinguished by operation of law and ceased to exist. G, that this honorable court has no jurisdiction where the right to sue no longer exists. Alternatively, A, the claimant's suit was vitiated by estoppel by conduct, election, and acquiescence. B, a party affected by estoppel is not allowed to aver against it or lead evidence in contravention of it. C, where estoppel applies, it outs the jurisdiction of court to entertain the matter that is affected by it. In support of the notice of preliminary objection is a 17-paragraph affidavit deposed by one Ruth Asulaga, who identified herself as a legal practitioner and a legal officer of the first defendant. The gist of the affidavit can be gleaned from the grounds of the application highlighted above. In the first defendant applicant's written address in support of the application, learned counsel to the applicant formulated two issues for determination. One is whether, in view of the express provisions of section 83(1) of the Nigerian Railway Corporation Act, this honorable court has jurisdiction to entertain the present act based on an alleged course of action that occurred not later than 2013 to 2014. 2, whether, having obtained the benefit of payment under a clemency on compassionate grounds, thereby causing the first defendant not to insist on the strict right of visiting the consequences of dismissal on the claimant, can the claimant come back to sue the first defendant, asserting rights that could only apply to staff retirement based on strict merits of good standing and applicable conditions of service tied to the latter? On issue number 1, learned counsel to the applicant made his submissions. Also on issue number 2, this I have to skip some parts, which makes this ruling very, very long. So I will leave his arguments on 1 and 2. Then, on receipt of the notice of preliminary objection of the first defendant, the claimant deposed a 20-paragraph counter affidavit with a written address in opposition to the notice of preliminary objection. The gist of the counter affidavit is that the claimant states that this suit was not filed 8 years after the course of action arose, that this suit is founded on the continuous injury caused by the claimant by the defendant for refusing or failing to make full payment of claimant's gratuity and pension, which took effect on 13 September 2011. That on the 8th January 2002, the claimant and 44 others were dismissed from work, to which they wrote several letters of appeal to the presidency until the presidency approved and commuted the dismissal to retirement, effective 13 September 2011. Rather than pay the claimant his pension and gratuity based on the 2011 salary structure, the first defendant paid the claimant based on the 2001 salary structure. Several pleas and letters were written to correct this anomaly, to no avail. There is a continuous refusal and failure of the first defendant to correct this anomaly that has led to the institution of this suit. In the claimant's respondent's written address in opposition to the defendant's notice of preliminary objection, the claimant's counsel formulated 2 issues for determination. And these 2 issues are: 1, whether the present suit filed by the claimant is statute barred in light of Section 83(1) of the Nigerian Railway Corporation Act. And 2, whether the present suit is estopped by conduct, election, or acquiescence. I shall also jump over the submissions on these 2 issues. Then, and said that on receipt of the claimant's counter affidavit and written address, the first defendant applicant filed a reply on points of law, dated and filed on the 12th September 2025, to which learned counsel to the applicant replied on points of law and adumbrated further on why this suit should be struck out for want of jurisdiction. This is the ruling. The court, having gone through the notice of preliminary objection, the affidavits and written addresses for and against the notice of preliminary objection, this court has sealed a sole issue for determination, and that is whether, given the facts and circumstances of this case, there is merit in this notice of preliminary objection. Whenever there is an application of this nature, challenging the jurisdiction of the court. It raises the twin issue of cause of action and limitation act law. This is so because any defense of limitation law is tied to when the cause of action arose or when the cause of action accrued. What then is the cause of action? Cause of action is the totality of material facts necessary to establish a legal right. It is simply a factual situation that exists and entitles one person to obtain from the court a remedy against another person. These facts constitute the essential ingredients of an enforceable right or claim. See the case of Esowe versus Adeferasi, quoted in 1985. And also Trowell and Sons Limited versus Ripstein, 1944. And also Savage versus Uwaicha of 1972. So, One All Nigerian Law Reports, Part 1, page 251 at 257. These facts are derived from the statement of facts filed by the claimant or the affidavit deposed by the claimant. Therefore, in determining whether or not a suit should be struck out due to non-disclosure of cause of action, the court must restrict itself to the facts pleaded in the statement of claim without resort to any extraneous facts. See the case of Mohammed versus Babalola, SAM, reported in 2011, LPELR, says Court of Appeal case. Given this, the court cannot look at the statement of defense of the defendant in drawing a conclusion as to when a cause of action arose. In this vein, this court, for the purpose of arriving at when the cause of action arose in this case, shall derive such insights from the averment made by the claimant herein in his statement of claim. From the cause of action, this court will now move to Limitation Act or law, which is generally referred to as statute of limitation. A statute of limitation is a provision of a time frame in which an aggrieved party can bring an action at law. If the action is not brought within the specified time frame, the action becomes statute barred, thereby divesting the aggrieved party of its right to bring the action. See the case of Ogunko versus Shell, authored in 2004, 6 Nigeria Weekly Law Report, Part 868, page 17. And also the case of Osun State Government versus Dan Lami, Nigeria Limited, reported in 2007, citation supplied. In the case hearing, the position of the first defendant, applicant, is that the claimant's alleged cause of action accrued between September 2013 and 24th November 2013, when he claims being shot
I don't know. Somebody tried to
Prefer
make a
respect.
call.
We prefer respect. I can't hear my lord. Good afternoon, Council.
Good afternoon.
Yes, sir. I don't know whether you can hear my Lord, please.
I'm not hearing anymore. I think there's some kind of glitch.
Yes, I believe so.
Can't hear my Lord. Yeah. Even the other person. Just look outside. Sure. Look. Just hold on. Hello? Attention that the council here is complaining about the. Okay. Huh? Shell, is it there? Is Shell there? Huh? Just tap the Zoom. Will it come? Maybe.
Okay, my Lord is back.
Okay, faster. That's
With profound respect, the device my Lord is using is still on mute. With profound respect, my Lord. With profound respect. Yes, my Lord. The device is on mute. We cannot hear my Lord.
I'm sure you can now hear me.
Yes, my Lord.
Yes, my Lord.
Thank you, my Lord.
Okay. So I was wondering at what point you stopped hearing me.
Well, my Lord, at the point when my Lord wanted to discuss when the cause of action arose.
Okay. What is that? Honestly, this is very terrible. Okay. So I'll continue. In any, you are going to have a copy of this. So I don't know if there is any way that I skipped. You will still see it.
Very well.
Yes, my Lord.
Are we on the same page?
Yes.
my Lord.
Okay. All right. Now, from course of action, this court now moves to limitation. So, Limitation Act, or law which is generally referred to as statute of limitation. A statute of limitation is a provision of a time frame within which an aggrieved party, are you hearing me?
Yes, my Lord.
Okay, within which an aggrieved party can bring an action at law. If the action is not brought within the specified time frame, the action becomes statute barred, thereby divesting the aggrieved party of its right to bring the action. See the case of Ogunko versus Shell, reported in 2004. 6 Nigeria Weekly Law Report, Part 868, page 17. And also, Osun State Government versus Darun Lami Nigeria Limited, reported in 2007. Citation fully supplied. So in the case hearing, the position of the first defendant applicant is that the claimant's alleged cause of action accrued between September 2013 and 2024. November 2013, when he claimed being short paid his pension arrears, that upon being aware of the alleged wrongful calculation and short payments, claimant decided to pursue non-judicial options that failed. By the provisions of Section 83(1) of the Nigerian Railways Corporation Act, no action can be instituted against the first defendant or is served after 12 months of the occurrence of such a cause of action. In the case hearing, this suit instituted on the 18th January 2022 was instituted more than 8 years after the cause of action accrued, contrary to Section 83 sub 1 supra. Now, as earlier mentioned, cause of action is not determined by the statement of the defendant, but by the statement of fact of the claimant. The highlights of the claimant's statement of fact is that after his initial dismissal on 8 January 2002, he and others affected appealed to the presidency, who committed their dismissal to retirement, effective 4th January 2002, with payment of pension commencing from 13th August 2011. Thereafter, the second defendant, in a letter dated 14th March 2013 and addressed to the President General of the Claimants Union Association, stated, contrary to the position of the first defendant, that 13 September 2011 is the effective date of the commutation from dismissal as approved by the presidency and not January 2002. The said letter also stated that retirement benefits, that is gratuity and pension, are effective 13 September 2011, being the effective date the communication that committed the dismissal to retirement was approved. However, rather than give effect to this, that the first defendant proceeded and calculated the claimant's gratuity and pension on the basis of salary structure existing as at January 2002, rather than the new salary structure that came into being from 1st January 2007 and applicable in 2011. Also, in a letter dated 26 September 2014, the national salaries, hello, tell them to give me water. Also, in a letter dated 26 September 2014, the National Salaries, Income and Wages Commission notified all parastatal and head of extra-ministerial departments that the president has approved a 33.0% increase in the pension of federal public servants effective 1st July 2010. That the defendant has the statutory duty to implement the increment in the pension payable to the claimant. From the above, it is obvious that the case of the claimant is rooted in his gratuity and pension payments. But it is not clear from the first defendant if the non-judicial means he claims the claimant resorted to were pre or post the non-implementation of the gratuity or pension payment up to the expectation of the claimant. Be that as it may, and being that the objection of the first defendant is that the action is statute bad, this court will proceed to look at same as well as the exceptions that come with it. In opposition to his preliminary objection, the claimant respondent stated in paragraph 4 of his counter affidavit that this suit is premised on continuous damage/injury caused by the first defendant by the defendant's inconsistent refusal and failure to make full payment of his gratuity and pension. In the claimant's respondent's written address, counsel submitted that Section 83 sub 1 of the Nigeria Railway Corporation Act cannot rob the claimant of his rights to gratuity and pension, nor can it be used to deprive him of instituting an action for the recovery of his pension and gratuity. He relied on his constitutional rights to pension and gratuity as guaranteed by Section 173 and 710 of the 1999 Constitution as amended. He also referred the court to the Supreme Court's case decision in the case of Abdul Rahman versus NNPC, reported in 2020, citation fully supplied. Given the nature of limitation laws, the court has created certain exceptions to limitation laws. In the case of Attorney General of Rivers State versus Attorney General of Bayelsa State, reported in 2013, 3 Nigeria Weekly Law Report, part 1340 at page 148 to 150, paragraphs F to A. The court held that in the case of a continuous damage, as in this case, an action can be brought outside the statutory period. In the case of Federal FGM versus Zebra Energy Limited, reported in 2002, citations supplied, the court held that the Public Officers Protection Law, which prohibits action brought outside the stipulated period, does not apply in cases of recovery of land, breaches of contracts, or claims for work or labor done. In the case of National Revenue Mobilization, Allocation and Fiscal Commission and others versus Ajibola Johnson and others, reported in 2019, 2 Nigeria Weekly Law Report, part 1656, page 247 at 270 to 271. The Supreme Court held that Limitation Act, that is the POPA, does not apply to contract of employment. Granted, this court is not unaware that the same Supreme Court in Abubakar Abdul Rahman versus NNPC in 2020, LPELR 55519, and also in the case of Mr. Edachaba and others versus University of Agriculture, Makurdi, and others, reported in 2021, citation supplied, reversed itself and held that limitation laws apply in cases of contract of employment. Whereas this conflict persisted, the Court of Appeal, in the case of First Bank Nigeria Limited versus Bosinike Chukwu Nkume, reported in 2021, well, it's unreported, made a distinction on when limitation laws will apply in contract of employment and when it will not apply. The Court of Appeal held the limitation law will not apply in employment contracts if there is a public officer. But if a public officer is not made a party, the limitation law will apply. Whereas the court appears to have settled that continuous injury is an exception to statutes of law of limitation, it seems the courts are not yet fully settled on Are you hearing me?
Yes, my Lord.
Yes, ma'am.
Okay. On whether such statutes of law apply in a matter rooted in contract of employment. Be it as it may, the reason the court delved into these exceptions is to make concrete the fact that statutes or laws of limitation act as a shield, but not a sword used to cut off litigants or cut off the jurisdiction of the court from what has been donated to it by the Constitution, which is the ground norm. In the case hearing, apart from stating that the Limitation Act hearing does not apply to matters of pension and gratuity, the claimant stated that the injury is a continuous one and cannot be affected by the Limitation Act. On continuous injury/damage, the Court of Appeal, in the case of Al Hassan versus Aliyu and others, quoted in 2009, citation supplied, held, and I quote, the Court of Appeal case, where the injury complained of is a continuing one, time does not begin to run for the purpose of the application of a limitation law until the cessation of the events leading to the cause of action. In other words, continuance of injury means the continuance or repeat of the act which caused the injury. It does not and cannot be said to mean the concomitant effects of the damage or injury, etc., unquote. In the case hearing, one of the complaints of the claimant is that the salary structure that was used to calculate his gratuity is that of 2001, as against that of 2011. He also complained that since his retirement, the federal government has reviewed upward what he should earn as pension. The question, therefore, is, has the first defendant affected these changes complained of? Has this injury damage abated? Until these complaints are attended to, the injury and damage suffered by the claimant has not abated. As such, it is a case of continuous injury and damage which can never extinguish the right of the claimant to sue on the same. And I so hold.
As God blesses.
Furthermore, arising from Section 173 and 210 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, monetary matters relating to pension and gratuity are sacrosanct, and no gimmicks or defense of limitation act or law can deride or override the sacredness guaranteed to this matter by the Constitution, which is the ground norm. Therefore, in the matter herein, which is rooted and founded on money claimed as pension and gratuity, Section 83(1) of the NRC Act is not applicable and I so hold. Consequently, the court finds no merit in this notice of preliminary objection, and same is hereby dismissed, and ruling is entered accordingly.
As my Lord pleases.
As well.
Very well.
As my Lord pleases.
Yes. So, where is the registrar? We shall now take a date and delve into the case.
As the God blesses, we are most grateful for the considered ruling, my Lord.
Thank you. April 23rd. How do you stand on the 23rd of April?
My Lord, 23rd of April would seem to be unsafe, although my diary is not here. I would rather my Lord would grant us a date in May.
in May.
Yes, my lord.
Yes, my lord. I will also constitute a date in May, my lord.
I see. Okay. If both of you want to go to May, our May should be
May 20.
20th day of May.
Incredible, my lord.
20th day of May. Is it convenient?
It's convenient, my lord.
So this matter is now adjourned to the 20th day of May 2026 for commencement of trial.
As the
We
court
are most
pleases.
grateful, my lord. As the court pleases.
Very well. The secretary has already taken this. Okay. Where is it?
Case
Okay.
number NICM/LA/353/2013 between Hyperion Limited and Peter Ibediako. My lord, parties are absent.
Okay. Appearances, please.
Respectfully, my lord, A.D.
Yes.
Taiwo in Sirim. My lord, my humble appearance is for the claimant defendant to counterclaim. I have with me my learned friend, Oluwatobi Idowu.
Okay.
May it please your lordship, Abayomi Akinshola. Abayomi Akinshola. Akinshola is without age, my lord. I announce my
Okay.
appearance for the defendant, claimants. We are most grateful, sir.
Yes. The judgment is okay. Okay. You can hear me well.
Yes, my lord, we can.
Okay. So this suit was instituted by the claimant by a general form of complaint dated and filed on the 8th day of July 2013, and by a letter amendment dated 17th October 2022. The claimant seeks the following reliefs. A declaration that the conduct of the defendant in divulging or disclosing official information of the claimant to third parties is unlawful and a breach of the terms of employment with the claimant. B, a special damage in the sum of 11,851,700 naira, representing the loss of earnings suffered by the claimant I shall start with Relief A. Relief A is a declaration that the conduct of the defendant in divulging or disclosing official information of the claimant to third parties is unlawful and a breach of his term of employment with the claimant. B, special damages in the sum of 11,851,700 naira, representing the loss of earnings suffered by the claimant as a result of the breach of the terms of employment by the defendant. C is general damages in the sum of 50 million naira only against the defendant in favor of the claimant. D is a cost of 10 million naira only, being the cost of filing this action. And E is perpetual injunction restraining the defendant or any person acting or benefiting in that behalf from disclosing, utilizing, and diverting the business or official information of the claimant. In summary, the gist of the claimant's amended statement of facts, dated and filed on the 17th October 22, is that the defendant was employed by the claimant by the letter of employment dated 16 December 2020 as the general manager, sales. By the terms of the employment, the defendant pledged not to be dishonest, corrupt, involved in embezzlement or falsification of records, not to disclose official information of the claimant or engage without permission, whatever on leave or whether on leave or otherwise, in any profit-oriented business profession or trade other than that one engaged to perform on behalf of the claimant. In the course of time, the defendant constituted himself into an agent of diversion of the claimant's business to her competitors, resulting in defendant's breach of his employment contract by divulging official information, engaging in competitive businesses with the claimant, and diverting claimant's business opportunities. This resulted in huge loss to the claimant, and this has led to the nature of relief sought in this suit. The defendant's statement of defense in summary. Okay, in the defendant's amended statement of defense dated 25th July 2023, the defendant, while not denying that he was in the employment of the claimant, stated, however, that he only had knowledge of the information disclosed to him and not all confidential information concerning the claimant, that he never diverted the business interests of the claimant, nor did he divulge information to the claimant's business competitors. The defendant also stated that he never absconded from work. Rather, sometime in May 2013, the defendant was invited by the police on fictitious allegation that was never revealed to him. In the course of the investigation, the defendant was barred from gaining access to the premises of the claimant. The claimant's personal laptop also was seized by the defendant. At the end of the day, the defendant was asked to hand over all the properties of the claimant in his possession to the claimant. He insisted that before doing that, his personal laptop must be returned by the defendant. On returning his laptop, he handed over all the claimant's belongings and properties in his possession. He noticed that the claimant wiped out valuable information and data from his laptop before handing it over. This made him to threaten that he was going to take action against the claimant who wiped out vital documents from his laptop, worth millions of naira. More so, the claimant owed him money during the course of his employment. In this light, the defendant counterclaims as follows. A declaration that the claimant defendant to the counterclaim acted substantially in breach and in violation of the terms of his offer or employment with the defendant's counterclaimant. B, a declaration that the claimant defendant to the counterclaimant underpaid the defendant's counterclaimant's salary throughout the period of his employment as the general manager, sales to the claimant. C, a declaration that the claimant's defendant to the counterclaim failure, neglect, and refusal to pay the defendant's incentives amount to breach of the employment terms made between it and the counterclaimant. D, a declaration that the defendant's employment, having not been formally terminated till death, and he, having not been tried and found guilty of any gross misconduct by any panel of the claimant defendant to the counterclaim or any law enforcement agency, is still in the payroll of the claimant defendant to the counterclaim and is entitled to all his remunerations and incentives as at today and hereafter until the final determination of this matter, and thereafter until final liquidation of the judgment sum herein. E, special damages in the sum of $30,013.61 being the total salary outstanding, which the claimant underpaid the defendant between July 2011 and date. F, special damages against the claimant defendants to the counterclaim in the sum of 33,067,352 naira, 89 kobo, being the total monthly incentives which it failed, refused, and neglected to pay the defendant counterclaimant throughout the said employment. G, the sum of 100 million naira only, being damages for the loss of valuable documents as a result of the claimant defendants to the counterclaim tampering with and or deleting the defendant's valuable documents on his laptop, and for the loss of reputation suffered by the defendant as a result of his harassment by the police on the instruction of the claimant. H, cost of this action. It must be noted that on receipt of the defendant's counterclaimant's statement, the claimant filed a reply to the defendant's counterclaim, and in return, the defendant also filed a reply to the defense of the claim on his counterclaim. Trial in this matter commenced before me on the 10th day of October 2023, to which one Mr. Timothy Amobeda testified as on behalf of the claimant. He adopted his witness statement on oath dated 17th October 2022 and tendered documents that were admitted in evidence as Exhibit C1 to C23. Subsequently, he was cross-examined by the defendant's counsel. There was no re-examination, and thereafter the claimant closed his case on the 5th day of March 2024. On the part of the defendant, he opened his defense on the 9th day of May 2024, testifying as DW1. He adopted his witness statement on oath dated 25th day of July 2023, gave oral testimony, and tendered documents that were admitted in evidence as Exhibits D1 to D9. He was cross-examined by the counsel to the claimant. There was no re-examination. Thereafter, the defendant closed his defense on the 28th day of May 2025. The case was then adjourned to enable parties file, exchange, and adopt their final written addresses. In the defendant's final written address dated 20th June 2025, but filed on the 23rd June 2025, learned counsel to the defendant counterclaimant formulated 3 issues for determination. The first one is whether the defendant counterclaimant has not proved his counterclaim against the claimant defendant to counterclaim hearing in the light of Exhibit C1, which establishes the relationship between the defendant and the claimant, or whether the court should not otherwise stop the claimant from reneging from the said contract of service. 2, whether the defendant's contract of service with the claimant was not determined unlawfully or summarily. And 3, whether the claimant defendant to the counterclaimant has proved his case. On issues 1 and 2, the learned defense counsel, while arguing issues 1 and 2 together, submitted that from all evidence adduced in this matter, the contractual relationship between the claimant and the defendant is regulated by Exhibit C1, which is the letter of employment. That in paragraph 7 of the claimant's amended reply to the defendant's counterclaimant's defense counterclaim, the claimant stated that it never confirmed the employment of the defendant after the probation period of 6 months. Defendants' counsel argued that, contrary to the position of the claimant, having allowed the defendant to continue working after the 6 months probation period has, by conduct, confirmed the employment of the defendant. He relied on Reliance Telecommunications Limited versus Adegboyega, reported in 2017. Citation supply. This is the submission of the learned counsel to the counterclaim, to the defendant counterclaimant, that the defendant counterclaimant has proved his case to be entitled to the relief sought in this case. On issue number 3, learned counsel to the defendant submitted that the case of the claimant is absurd and unproved, as the claimant who alleges that the defendant divulged or discloses confidential information to third parties did not specify or prove the nature of the information. Disclosed and the basis for its entitlement to the special damages. That the claimant simply dumped documents on the court without tying the evidence to its pleadings. On this point, defendants relied on the case of Maku versus Al Makura, reported in 2016, 5 Nigeria Weekly Law Report, Part 1505, page 201. He also referred the court to the case of Khan versus Nyako, reported in 2015, 18 Nigeria Weekly Law Report, Part 1491, page 352, where the court held that it is the duty of a party relying on documents in proof of his case to tie or relate the document to the case. That the claimant was unable to prove any of the special damage claimed, and as such, his claim remains in the realm of speculation. He relied on the case of Adesanya and another versus registered trustees of the Church of Nigeria, Anglican Communion, and others, reported in 2021, LPER 56001, Court of Appeal. In the submission of the defense, it is the submission of the defendant that the claimant has not proved his case, nor to be entitled to the relief sought. In the claimant's final written address, dated and filed 17 July 2025, the claimant's counsel formulated 4 issues for determination. One is, what were the terms of the defendant's employment with the claimant? 2, whether the defendant was in any way dishonest in the course of his employment with the claimant, and or if his actions undermine the claimant's business. 3, whether the defendant has established any equitable basis or conduct sufficient enough to entitle him to the reliefs or compensations sought from this honorable court. And 4, whether the claimant has proved his case to be entitled to the claims against the defendant. On issue number 1, claimant's counsel submitted that the defendant's employment was regulated by the employment letter dated 16 December 2010, that is Exhibit C1, and on other terms of service stated in the company's employment, and that though the defendant alleged that he signed the company's employment handbook under duress, he was unable to prove that he did sign it under duress. That the defendant, having failed to prove the allegation of duress, this allegation on duress must fail. He relied on the case of Sadiq versus Balarabe, voted in 2020, LPELR 52114, Court of Appeal. It is the submission of learned counsel to the claimant that the employment letter of the defendant incorporates the employee's handbook, and as such, the employee's handbook is applicable and governs the defendant's employment with the claimant. He therefore urged the court to so hold. On issue number 2 and 3, learned counsel to the claimant submitted that from Exhibit C11, C13, C14, C15, C16, and C18, it is clear that there was a breach of confidentiality on the part of the defendant. That for the actions of the defendant which were determined to, which were detrimental to the business interests of the claimant, he was reported to the police, and his action of absconding from work thwarted the criminal investigation of the claimant. On the non-confirmation of the employment of the defendant, the claimant stated that the confirmation was discretional. As such, the claimant was not under any legal obligation to confirm the employment of the defendant. That the part on confirmation in Exhibit C1, which is the employment letter, states that the claimant may confirm the employment of the claimant. On the interpretation of the word may, learned counsel referred the court to the case of Mokpai. This was the University of Benin, reported in 2002, 17 Nigeria Weekly Law Report, Part 795, page 139, where the Court of Appeal held that the word may is mere directory and not compulsory. It is also the submission of learned counsel to the claimant that the employment of the defendant was not confirmed because he didn't merit the condition of being confirmed. On issue number 4, the claimant, basing his argument on evidence already before the court and statutory authorities, submitted that the claimant has proved his case to be entitled to the relief sought in this suit. Learned counsel to the claimant therefore urged the court to grant the relief sought by the claimant, but the court should dismiss the claim of the defendant counterclaimant. I must point out that on the receipt of the claimant's final written address, the defendant counterclaimant filed a reply on points of law on which he replied on points of law and elaborated further on these points. And that was the end of the trial. Now the court, having gone through the case of the claimant, defense of the defendant, counterclaimant, and evidence led by the claimant and the defendant, this court distilled 2 issues for determination, to wit, 1, whether the claimant has proved his case to be entitled to the relief sought. 2, whether the defendant counterclaimant has proved his claim to be entitled to the relief sought in his counterclaim. On issue number 1, that is whether the claimant has proved his case to be entitled to the relief sought, the settled law is that the burden of proof rests on who asserts. A civil case is decided on the preponderance of evidence and on the balance of probability. See the case of Ayetoro Contract Company Limited versus NSCB, voted in 2003, citation supplied. The court puts all the evidence before it on an imaginary scale, and the party whose evidence steals more on the balance of probability is deemed to have proven his case on that preponderance of evidence. The case of the claimant hearing is that the defendant, who was an ex-staff of the claimant, compromised privileged information that was of a confidential nature to the advantage of third parties who happened to be in the same line of business whom the claimant refers to as competitors. By compromising this information, the claimant breached the terms of his employment captured in his employment letter, as well as the employee's handbook. In defense to this, the position of the defendant is that companies that the claimant referred to, that is Javanet Internet Cafe Limited and Linus Academy Limited, are companies well known to the claimant, to which he was a shareholder/director even before joining the services of the claimant, and that he did not compromise any information. One of the companies referred to, that is SkyStar, is a company founded during the pendency of defendant's employment with the claimant, and it was also a partner to the claimant. Defendant, in his amended statement of defense, went ahead to explain how any information he gave out or any relationship he had with some of these companies were only in his capacity as a general manager, sales. And given the partnership of the claimant's company also has with the other company, in all, the defendant didn't find anything dishonest in his dealings with these companies. Defendant also put up the defense that distinguishes what some of these companies do from what the claimant's company does, thereby negating the position of the claimant that they were its competitors. Be it as it may, the duties of a trial court as to what to do on evidence before it are well espoused in the case of State versus Ibangbe, quoted in 1988, citation supplied, where the Supreme Court, the Oputa JSC, held as follows, and I quote, "The role of trial court is to hear evidence, to evaluate that evidence, to believe witness who testified, and to decide the merit of the case on the findings. Where a trial court acts on speculation rather than on the evidence, then it has abandoned its proper role. No trial court has a right to draw conclusion of facts outside the available evidence. Such conclusion will be regarded as perverse," unquote. Justice Esowe, JSC, at page 577, also held, and I quote, "A judge of first instance decides on the evidence led by the parties to a case before him. He does not, with due respect, concoct evidence. He does not imagine evidence. He interprets a situation as per cold facts before him and not as per what he would have preferred the facts to be," unquote. Given the foregoing, this court is bound to look at the evidence before it and not to look outside what is before it. The sum of the evidence before the court is that what is proved is appropriated to what is pleaded. In this vein, what is not proved loses its vitality in the pleadings. This is more so given the settled position of law that pleadings do not tantamount to evidence or proof. As such, what was pleaded but not proved will be deemed to be what was pleaded without proof. And as such, what was pleaded but not proved will be deemed to be that what was pleaded without proof has been abandoned. In this vein, while looking at the pleadings and proof of the pleadings before me, value will be accorded to pleadings that were proved and pleadings that were not proved will serve no value because they will be deemed to have been abandoned. From the evidence before me, it is not in doubt that the claimant was employed in December 2010 by virtue of Exhibit C1, which is the employment letter. It is not in dispute that Exhibit C1 governs the terms and conditions of the employment. However, what is in dispute is Exhibit C2, which is Employees Handbook, to which, according to the claimant, also governs the terms and conditions of the employment. While to the defendant, it doesn't govern the terms and conditions of his employment. In claimant's final written address, part of his argument is that Exhibit C1 incorporates Exhibit C2 in the employment. Learned counsel to the claimant referred the court to a paragraph at the tail of Exhibit P of page 2 of Exhibit C1, which reads, quote, all other terms and conditions of service will be explained during your induction, unquote. Whereas this court takes this paragraph of what it is, it did not specifically mention Exhibit C2, which is captured condition of service of Hyperia Limited Staff Handbook. Furthermore, I noticed that whereas the employment of the defendant was in 2010, the signing of Exhibit C2 by the defendant was in 2013, 3 years after his employment. According to the defendant, he was coerced or was put under duress to sign the said Exhibit C2. Considering the defense of the defendant that he was put under duress, this court wishes to state that whereas the defense avails the defendant, it is desirous that he proves the element of duress that he complained of or took defense in. From the evidence before, defendant did not lead convincing or satisfactory evidence in proof of his defense of duress. In this regard, the defense of duress goes to no issue, and I so hold. Still on Exhibit C2, this court is very much aware. This court is very much aware that the track law is that an employee hand, even though not expressly stated in the employment letter, can be implied as forming part of the terms and conditions of the employment. Furthermore, this court is also very much aware that it is strike law that a document needed to be signed cannot be said to be executed until and unless signed. Exhibit C2, even though it's an employee handbook, has a column for signing. This column was signed by the defendant in 2013. Given this, it is my opinion that the effective date of Exhibit C2 is 15th January 2013, when the defendant signed and not before. The date of signing Exhibit C2 becomes the effective date of Exhibit C2, and the day it becomes enforceable against the defendant, and I so hold. The next question that begs for answer is, if the defendant was found to be dishonest in his dealings as an employee of the claimant prior to 2013, when he signed Exhibit C2, will he be held liable? In the case of Diabrunassi and another versus Antoine Ruzek, quoted in 1973, LPELR 1946 Supreme Court, the court held, and I quote, that it is also trite that every agent owes his principal certain fiduciary duties, which are otherwise known as duties of loyalty. While many of these duties are imposed on the agent by the terms expressed or implied in the contract, others are duties arising independently of the contract and are imposed by equity on the agent as a result of his special relationship with his principal. From the foregoing, it is obvious that the defendant or any employee of that matter owes his employee certain fiduciary duties, which, even if not expressly stated in the employment, can be implied. In this vein, if the defendant is found to be dishonest in any way to the claimant prior to January 2013, when he signed Exhibit C2, or after that, he will be held liable with or without Exhibit C2, and I so hold. I have looked at the documents tendered by the claimant to substantiate the dishonest dealings of the defendant whilst in their employment. I have also taken a critical look at the defense of the defendant. I noticed that even though the defendant puts a defense that whatever information divulged to the third-party companies or whatever dealings he had with them were done in his capacity as the manager sales to the claimant and as a result of the partnership of the claimant with such third-party companies. What is glaring is that he was acting alone without being answerable to his superiors or carrying the claimant company along. I also noticed that even though the defendant wanted the court to believe that, as at the time the claimant entered a partnership with SkyStar, the claimant knew he was a director at SkyStar. There is actually no credible evidence to substantiate same. The issue of loyalty extends to disclosure. Therefore, if a company in which you are employed is advised into entering a partnership with another company in which you are a director, courtesy demands that you formally disclose this to the company. It is not open for you to say that the employer ought to have known that the person who signed as Mike Kemakonam was your brother. In this vein, this court finds and holds that the defendant was dishonest in not formally disclosing his relationship as a director at SkyStar to the claimant, as at the time the claimant entered a partnership agreement with SkyStar. Furthermore, the defendant also put up a defense that he did not give undue advantage to third-party companies, as the business done by the alleged third-party companies was at variance with the nature of business done by the claimant. I have taken a holistic look at the evidence before me, and I have discovered even there may be specifications, there may be specialization, the business of the claimant as well as the alleged third-party companies in the general field of ICT, information and communication technology. Furthermore, as evidenced by Exhibit D1, it appears that even if a contract is awarded that is outside the specialization of the claimant, it can outsource it to a partner company. Therefore, it is my opinion that it is not in the place of the defendant to detect to the claimant the business opportunity should take advantage of if it is available. I also find it quite dishonorable that most of the overtures made by the defendant to other third-party companies whilst in the employment of the claimant were made using official email, that is peter@hyperia.com, of the claimant to carry out these deals. This way, it will look more convincing that the defendant was acting on behalf of the claimant, while in fact, he was acting for his own benefit and the benefit of the companies he was associated with as a shareholder director. Be it as it may, the court has earlier held that is liable for his actions of dishonesty with or without Exhibit C2. Therefore, arising from the findings of the court above, this court holds that the defendant was dishonest in his dealing with the claimant as an employee, and he also used his position to give third-party companies undue advantage over the claimant. Arising from the above, relief one of the claimant is bound to succeed, and I so hold. Relief number two of the claimant is on special damages of the sum of 11 million odd, being loss of earnings suffered by the claimant as a result of breach of terms of employment by the defendant. Now, this relief too borders on special damages. The settled principle of law on special damages is that same must be strictly pleaded and proved. The object of special damages and the distinction between special and general damages was well enunciated in the case of Akin Kube versus EH Nigeria Limited, reported in 2008, citation fully supplied, where the court held, and I quote, in the consideration of how a plaintiff must deal with damages in his statement of claim, it is often necessary to make a basic distinction between general damages or damages and special damages or damages. Special damage or damages. General damages often consist in all items of loss which a plaintiff is not required to specify in his pleadings in order to allow him recover monetary compensation in respect of them at the trial. What constitutes general damages in pleadings is made clearer when considered in relation to the two other meanings of the term. The first of these goes to liability, and the second goes to proof. If an item of damage is general for the purpose of liability because it represents a normal loss, it will be general for the purpose of pleading insofar as its existence cannot take the defendant by surprise. If an item of damage is general for the purpose of proof because it is inferred or presumed by the court, it will be general for the purpose of pleading, since what the law is prepared to infer or presume in the plaintiff's favor, the defendant cannot contend will surprise him at the trial. But special damages consist in all items of losses which must be specified or stated by him in his pleadings before they will be allowed to be proved at the trial and recovery of same granted. The basic test of whether damage is general or special is whether particularity is necessary and useful to warn the defendant of the type of claim and evidence, or if the specific amount of claim which he will be confronted with at the trial. In the instant case, the respondent claimed special and general damages, and by the rules of pleadings, thank you, they must plead special damages and give particulars thereof before they would be allowed to lead evidence in proof thereof, etc. Unquote. Special damages are in the class of their own, requiring strict proof, which must have been specifically pleaded and, of course, strictly proved. The burden of proof is on anyone claiming it to prove strictly that he did suffer special damage as claimed. Arising from the above, it behoves the claimant who claims special damages to the tune of 11 million odd has the onerous duty of pleading and leading evidence in proof of his claim. From the evidence before the court, the money herein claimed is for missed opportunities of contracts which were awarded to third-party companies instead of the claimant. Whereas it is understandable that the claimant would have made profits from the contracts if awarded to it, it is also understandable that claimant would have expended money in executing these contracts. Therefore, the total amount of the contract sum wouldn't have accrued to it as profit. Furthermore, it is also probable that it may have also run at a loss. In this vein, it is quite out of place to move the court to award this sum demanded by the claimant. Furthermore, there is no concrete evidence before the court capable of satisfying and convincing the court that the claimant is entitled to this sum as special damages against the defendant. Therefore, this relief too is bound to fail, and I so hold. On relief number 3, which is for the sum of 50 million naira only as general damages, this court wishes to state that this relief is ancillary to relief number 1. However, given the facts and circumstances of this case, this court is minded to grant the sum of 4 million naira assessed as general damages in this case. Relief number 4 is on the sum of 10 million naira only, being cause of this suit. This court would like to state that given the facts and circumstances of this case, the court is not minded to grant any sum in favor of the claimant as cost of filing this suit. Consequently, this said relief is bound to fail, and I so hold. Relief number 5 is for perpetual injunction of the defendant. This relief is quite wide and unlimited in nature, which, from the look of it, will limit the fundamental rights of the defendant as guaranteed by the Constitution of the Federal Republic of Nigeria 1999, which is the ground norm. In this vein, this court is not moved to grant same. It is my opinion that whatever loyalty the defendant or the claimant was limited to his period of employment with the claimant. Okay. Issue number 2, formulated by the court, that is whether the defendant counterclaimant has proved his case to be entitled to the relief sought in his counterclaim. The counterclaim by the defendant is derivable from the allegation by the defendant that his employment was not properly determined and money was owed him during the dependency of his employment. The defense put up by the claimant to this is that it did not confirm the employment of the defendant to enable him benefit some of the monetary benefits claimed. The claimant also put up a defense that it was the defendant who absconded from work during the criminal investigation of his dishonest dealings with the claimant. Sorry. The claimant also alleges that his personal laptop was forcefully taken from him and valuable data worth millions of naira were deleted. The claimant, while not conceding to deleting valuable data worth millions of naira, stated that the laptop was not personal, but official laptop given to the claimant. On the issue of the ownership of the laptop, I will adopt the earlier principle of law stated above, that it is the duty of the person who asserts to lead evidence in support of his assertion. As for this, as far as this issue of laptop is concerned, there is no evidence before me to arrive at the true owner. Therefore, there is nothing to substantiate that the laptop belongs to the defendant or is his personal laptop to warrant the information or data in it to belong to him. Therefore, any claim on this is bound to fail. As for the defense of the claimant, that it never confirmed the employment of the defendant, this court wishes to state that this defense is neither here nor there. This is so because in modern jurisprudence of labor law and matters, the court can infer the existence and non-existence of employment relationship from the conduct of the parties, just as it can infer confirmation of employment from the conduct of the parties without any formal confirmation. From the evidence before me, the defendant was employed in December 2010, and his employment was to be confirmed 6 months later. The claimant did not terminate the employment of the defendant 6 months thereafter. Rather, it kept the defendant in the employment until 2013, when his employment came to an end. It is my opinion that even though the claimant did not issue the defendant any opinion, only formal confirmation letter, it can be implied that the employment of the defendant was that of a confirmed employee, the claimant having kept the defendant in his employment far beyond 6 months after his probation. In this vein, the defendant is entitled to the salaries of a confirmed employee from the period after the confirmation of his employment to the period his employment came to an end, and I so hold. As for counter-claimant's relief extending to periods after the severed employment in 2013, this court wishes to state that it cannot grant SEM, for, as earlier stated, it is clear from the conduct of the parties that whatever employment relationship that existed between them ceased in 2013, and I so hold. Furthermore, on reliefs bordering on commission, this court is hard put to grant SEM, arising from the fact that these reliefs were based on performance evaluation from the claimant. Therefore, in the absence of such performance evaluation, this court is not minded to grant the commission sought by the defendant, and I so hold. Consequently, the counterclaim of the defendant's counterclaimant succeeds only to the extent that the claimant shall pay the defendant balance of his salary that accrued to him as a confirmed staff of the claimant from the period after his probation period of 6 months until the employment relationship was severed in 2013. I shall make no orders as to cost. In this case, parties are to bear their respective costs, and judgment is entered accordingly. Yes.
as the court pleases, we are most grateful to the court for the well-considered judgments. We are most grateful, sir.
Thank you very much.
Yes.
Okay.
As the court pleases, we are most grateful, my lord.
Shall I mute?